After the law allowing the government's controversial asset sales passed through Parliament yesterday, the iwi which owns Lake Taupo said it may lodge a Treaty of Waitangi claim if its concerns aren't met. The Finance Minister, Bill English, initially said that such a claim by Ngāti Tuwharetoa may be appeased by setting aside shares for Māori. But since then, his boss has put the kibosh on that.
There's no merit to any litigation, and that the issues of water, which sit at the heart of any potential litigation, have been well and truly covered off through lots of other things we're doing.
So, do Māori have special rights when it comes to water? Jacinta Ruru is a senior law lecturer at Otago University, and she's with us now. Good morning.
Kia ora, Petra.
Could we have a look at, do you think that Ngāti Tuwharetoa has a case that needs to be explored here as to water rights?
Most definitely. This whole issue has been politically hot for decades now, and it's interesting that John Key is saying that there's nothing to litigate here, where we have a cabinet paper of only about 2 years ago describing Māori rights to water as undefined and unresolved. So it's definitely something that needs to go through our courts or our tribunal.
So we understand that basically political parties have avoided it. Why have they avoided resolving water rights?
It is a very difficult issue. It's a thorny issue. It's one that, on the one hand, we have our common law doctrine and common law, which has a number of elements to it, and John Key very much clings to this idea of the common law that no one owns water. But we also have another common law doctrine that holds that Māori property should be protected when we have a change of sovereignty. So that's what happened here in New Zealand, and it's called our Doctrine of Native Title, and that potentially provides protection to Māori, to water.
So could this issue potentially resolve or help resolve that debate? Because I guess while the power generation was in national interests, everybody in New Zealand was benefiting from it, then the owners of the riverbeds and the lakes were happy to see that happen. Now that it's going to be commercialised, they're saying they have a right to benefit from that commercialisation. Definitely,
and that's Māori right to be able to seek governance of water, and this is particularly if this is what interests them, and this should be able to pursue this.
Can you see Ngāti Tuwharetoa taking this to court?
I don't know the exact details of Ngāti Tuwharetoa and what they're exactly claiming, but generally this whole issue has been bubbling up for a number of years now, and a number of iwi have been indicating that they will take it to the court. So if it's not Ngāti Tuwharetoa, it will be another iwi that will take it to the courts, I imagine.
And many New Zealanders would claim you can't own water and air. What do you say to those arguments?
Well, it's a fallacy, really. We've been talking, when we look at water, for every day local government is making decisions as to who has a right to be able to take water, use water. We talk about water in terms of property rights. So water isn't like air. It's not regarded as a common good in the daily lives of our power generators, our farmers and so on. So, yeah.
All right, Jacinta Ruru, plenty of debate yet to happen. Thanks for joining Breakfast this morning.